Hello, I'm Professor Kozlowski. Welcome to my webpage here at George Mason University. See a list of the courses I teach, many of which are web-based televideo courses, which oftentimes use materials from the monthly law review articles that I've written starting in January of 1982 to the present, the monthly law review column in Parks and Recreation magazine, which is the official publication of the National Recreation Park Association. And there's a link to an archive of these columns on my George Mason webpage. And today we'll be looking at a recent article from March of 2012 entitled Cliff Collapse Accidents Test Recreational Use Statutes. And this particular article illustrates an important theme in recreational injury liability. And in fact, when there's a landowner liability case from a defense standpoint, one of the first questions you ask is whether there's an applicable recreational use statute. Because if that indeed is the case, as we'll see, it lowers the standard of care where the landowner will not be liable for ordinary negligence. There has to be proof of gross negligence or willful wanton misconduct. So as noted in the article, with minor jurisdictional variations, most jurisdictions have a recreational use statute. Most of these are based on a 1965 model state statute. And the point being, these were enacted to encourage private landowners to open their land up for public recreational use free of charge. But in fact, as we'll see, many of these statutes have also been found applicable to public landowners. And under a recreational use statute, a landowner owes no legal duty to guard, warn, or make the premises reasonably safe. The only duty is to avoid willful wanton misconduct and assumes that the land is provided free of charge for public recreational use. So in lowering the standard from ordinary negligence, mere carelessness, to gross negligence, which is more outrageous misconduct, recklessness, misconduct which demonstrated utter disregard for the physical well-being of others, makes it much more likely that one of these landowner liability suits are either dismissed on a motion for summary judgment or a judgment will be rendered for the defendant landowner, because the burden of proof is much more difficult when you have to allege and ultimately prove gross negligence as opposed to ordinary negligence. Now, typically, in illustrating the law in law case books, they'll take two cases which seemingly have similar facts, and each case will go a different way. And in trying to figure out the distinction between the two, gives you a better understanding and grasp how the particular legal principle works. That's what we'll do today with the state recreational use statutes. We have a case out of Texas, the Kirwan case from the Texas State Supreme Court, in which no gross negligence or willful wanton misconduct was found, in that there was no conscious indifference, which is another term used in defining gross negligence. Conscious indifference or utter disregard for the physical well-being of others. None was found in that particular Texas case. We'll also look at another case involving a state recreational use statute in Rhode Island, the Berman case, where a series of similar injuries indicated the landowner knew of a serious risk and did nothing in response, which the court found that the number of serious incidents involved could establish the necessary conscious indifference to constitute willful or malicious failure to guard or warn against a known dangerous condition, and therefore the immunity under the recreational use statute would not apply. Further, as we'll see, as a general principle of landowner liability is based on an unreasonably dangerous condition, generally, and this presupposes that the landowner knows of a dangerous condition, but it wouldn't be known or obvious to the recreational user through the reasonable use of their senses. And in fact, if the general scope of the risk is open and obvious through the general use, reasonable use of one's senses, then there should be no liability on the part of the landowner. That if it's an open and obvious risk, the recreational user, reasonably looking out for his own safety, should be able to avoid it. If he chooses to encounter the risk, even though obvious, that might constitute an assumption of risk. So whereas the cliff, as we'll see in Kirwan, is considered an open and obvious natural condition, Berman case was seen to be more latent or hidden to unsuspecting visitors, and unlike a natural phenomena like a cliff, which is what you see is what you get, the risk is open and obvious, as we'll see it was the case in Kirwan. In Berman, this situation was much more dangerous, treacherous than it appeared to be, and could be construed as even trap-like, which is the type of condition necessary to establish the willful wanton exception under the recreational use statute, as we'll see. So let's take a look at the first of the two cases and compare and contrast these, and perhaps get a little better insight into how the recreational use statute works. In this case involves allegedly unstable rocks. In the case of City of Waco versus Kirwan, Texas Supreme Court case for November 20th, 2009. And the issue in this case, the state Supreme Court would consider whether a landowner owes a duty to warn or protect recreational users against the dangers of naturally occurring conditions on the landowner's property, not only under a recreational use statute, but generally naturally occurring conditions are considered open and obvious and not necessarily unreasonably dangerous under the circumstances. Your reasonable expectation of safety when you're out in the great outdoors is certainly much less than when you're in a more controlled man-made environment. So here the state Supreme Court cited the Texas recreational use statutes, fairly typical of these statutes based upon the 65 model statute, and expressly provided the landowner does not assure that the premises are reasonably safe for recreational purposes, which would otherwise be the case under common law for invitees on the premises, those who you encourage to be there for recreational purposes. But where a state recreational use statute applies, that status of recreational user, as we'll see under an applicable statute, the legal duty of care is much less. You don't have to make the premises reasonably safe for recreational users. You simply have to avoid willful wanton misconduct. is generally the case, and as I mentioned, Texas Supreme Court acknowledges here, the legislative intent of these recreational use statutes was at first to encourage private parties to open their land for public recreational use free of charge, but in many jurisdictions, as the case is here in Texas, it also applies to governmental entities. So when the statute applies, there's no liability for ordinary negligence. The plaintiff, in order to recover, requires proof of gross negligence, malicious intent, or as mentioned here, bad faith on the part of the governmental unit to establish liability for an injured recreational user on government-owned property. And distinguishing gross negligence from ordinary negligence, where an act of or omission, mere carelessness, might constitute ordinary negligence. For gross negligence, it goes way beyond mere carelessness, but it shows an utter disregard and awareness on the part of the defendant landowner of an extreme degree of risk, which would go beyond mere carelessness and indicate, as noted here, a conscious indifference to the right, safety, or welfare of others. Now, looking at the facts of this particular case in Kirwan, the decedent here is college student Brad McGee fell 60 feet to his death, and the solid ground on a cliff collapsed beneath him. And he'd been watching boat races at Circle Point Cameron Park, a municipal park located in the city of Waco, but was a rather resource-based site, not highly developed as city park that you might envision. So here the cliff was a natural condition altered only by nature. And it is what you see is what you get. It was an open and obvious natural phenomenon, and such rock formations here typically could include loose rock and natural cracks. The city, however, and this would undercut any allegation that there was a total lack of care or conscious indifference to the physical well-being of others necessary to establish willful wanton misconduct. The city had placed a sign at this site and said, "For your safety, do not go beyond the wall." Furthermore, the city had not altered, modified, or excavated the limestone cliff beyond the stone wall in front of the cliff. It hadn't been altered in any way. It was no man-made interference. It was once again a natural geographic phenomenon. Here, despite the warning, McGee had crossed the wall to the site where he fell to his death. Now, the responders to the scene stated that they were aware of 6 accidents involving incidents, falls, and cliffs in Cameron Park, including the situation involving McGee. So, to that extent, would it constitute willful wanton that there are, and we'll see in the next case, they focused on the number of incidents prior to, which might be indicative of a conscious indifference. But here we'll see a distinction. Although there were 6 incidents involving the cliff, the other incidents were qualitatively different from that involving McGee's death. And so while he was not aware of any other injuries caused by crumbling rocks, he did testify he could see where rocks had fallen along the trails from the cliffs over the years. And again, this would be sort of a naturally occurring phenomenon, which would be what you see is what you get out in this kind of terrain. So Deborah Kirwan, the representative of McGee's estate, to overcome the immunity of the state recreational use statute, would have to allege, as she did, that the death was caused by the city's gross negligence. And the court noted to establish gross negligence, once again, Kirwan would have to show the city's subjective awareness of an extreme danger and the city's conscious indifference to the risks. And in order to do so, Kirwan cited the lack of any sign specifically warning of the risk of fatality resulting from the condition in Cameron Park. A warning, however, simply provides you of risk knowledge known to the landowner, but wouldn't be apparent to the recreational user through the reasonable use of their senses. Now, a sign was provided, but it was not a warning because it did not provide any risk information. Once again, a warning tells you of risks known to the landowner that wouldn't be otherwise obvious to you. So although this is not a warning sign, it's not a prohibitory sign, but it suggests that in looking out reasonably for your own safety, you should not go beyond the wall, which suggests that McGee here, perhaps on balance, the incident was attributable to his own failure to look out unreasonably for his own safety, that this particular site was dangerous, but not unreasonably dangerous. Unreasonably dangerous, again, presupposes that the landowner knows and it wouldn't be apparent to the recreational user, and such dangerous conditions are more likely to exist where it's a man-made situation as opposed to an open and obvious natural condition, geologic formation like a cliff. And the risk of falling from a cliff would generally be considered open and obvious. And within the scope of the risk when you're near a cliff, would one of those risks include perhaps unstable rocks when you were in this particular area? So Kirwan, however, said that it was not open and obvious and that there should have been a warning sign attached to the sign that already did exist, warning of unstable rocks, because other park patrons had died or been seriously injured by, she claimed, similar conditions. So the city, however, in response said, as a matter of law, it's not gross negligence for failing to warn of the inherent dangers of nature. Not only is it not grossly negligent, as would be required under state recreational use statute, but the failure to warn of inherent dangers of nature is generally not even considered ordinary negligence. So the city argued that Kirwan had failed to allege the city was grossly negligent in creating a condition that a recreational user would not reasonably expect on the property in the course of permitted use, that given the rough terrain in this park, it was as safe or as dangerous as it appeared to be. The trial court agreed and dismissed Kirwan's claims against the city. The state appellate court, however, reversed the trial court's decision. And the appeals court said the trial court had erred in effectively concluding that all natural conditions per se or automatically are open and obvious and could never be basis for a premise liability or premise defect claim. And as a result, the appeals court found that even with the recreational use statute applicable, that there could still be a claim for gross negligence based on a natural condition where the plaintiff could show that it was not open and obvious, that it in fact was trap-like, if you will. And the question is, and that's what we'll see actually in the next case, the question here is, were there sufficient facts to allege that this particular cliff condition was indeed hidden, latent, or trap-like, or was it within the general scope of the risk posed by this particular cliff, and therefore it was an open and obvious natural condition where there would be no reasonable minds couldn't differ, where a jury could find gross negligence. So appeals court found that because a case could be made for gross negligence here, the trial court should have allowed it to proceed to trial and should not have dismissed it based upon the recreational use statute. And the state Supreme Court, Texas, agreed to review this decision. And we'll see that they wind up reinstating the trial court's determination. So, key point is this idea of, in landowner liability, of obvious natural conditions. And as noted by the state Supreme Court here, and a general principle in this area of landowner liability, is that generally a landowner has no legal duty to warn or protect recreational users from obvious defects or conditions on the premises. Rather, a landowner could assume that the recreational user needs no warning to appreciate the dangers of natural conditions, that the general scope of the risk should be apparent through the reasonable use of your senses. What's the general scope of the risk if you're hanging out around a cliff that you may fall, or perhaps part of it may give way? And the court noted here, in general, that nature is full of risk, and they're certainly foreseeable that can lead to serious injury, even death, and that the great outdoors, including state parks or city park here with the rough terrain, that have numerous potentially dangerous natural conditions. The court noted, such things as cliffs, caves, waterfalls, swamps, wetlands, various animals and creatures. They come with the territory. So if you want to go out into the great outdoors, then the land is as reasonably safe or as dangerous as it appears to be. So although landowners may know of these natural formations and animals and critters that come along with the natural environment, reasonableness is a two-way street, and the court noted that reasonable recreational users who choose to visit a property for rec purposes will also be assumed to have the awareness of the inherent risks of going out into the great outdoors, interacting with nature. So unlike being in a structure that's subject to a building code and safety codes and the like, you can't expect that sort of situation with a natural cliff. So here, looking at this, found that both McGee and the city could reasonably expect that the cliff would impose some sort of risk that could include looking at the loose rocks and cracks at the cliff's edge, that should have alerted a recreational user, McGee in particular, although he may not have expected it, the possibility of crumbling rocks, that the rocks could give way. You know, if you're traversing it, you could lose your footing and go over the cliff, or here, the rock formation would give way. So the court found it to be obvious to reasonable recreational users that comes with the territory, that many cliffs have the potential to crumble. And it was equally known to both the city and McGee. And an unreasonably dangerous situation causes injury that would provide a basis for ordinary negligence usually presupposes the landowner knows, but the recreational user wouldn't, through the reasonable use of their senses. So here they're suggesting there wasn't even a basis for ordinary negligence liability under general landowner liability principles, let alone if the recreational use statute would apply here, which would require proof of willful, wanton, gross negligence. And even though it was open and obvious, and keep in mind willful, wanton presupposes utter, total indifference to the physical well-being or safety of recreational users, the court here noted that the city had erected a wall and a sign telling visitors, hey, stay away from the cliff's edge. Furthermore, when he went beyond the sign, you could see that the cliff consisted of loose rocks and cracks. While you wouldn't expect it to give way, this would certainly, through the reasonable use of your senses, looking out reasonably for your own safety by the recreational user, this would give you a heads up that, hey, maybe this isn't a good place to watch the boat races. So even assuming that particular risk at the cliff's edge, the crumbling of a large section of cliff, generally you don't have to foresee exactly what's going to happen to you. If the general scope of the risk is open and obvious, apparent to the reasonable use of your senses, that's sufficient to put you on notice, and on balance, perhaps the responsibility is on the part of the recreational user here, failing to look out reasonably for his own safety as opposed to the landowner. Because clearly if there's landowner liability here, it would certainly perhaps close the site and there'd be less land open for public recreational use free of charge, which would go against the whole purpose of the state recreational use statute. The court also addressed this issue of past injuries at the cliffs, as I mentioned, and would this indicate sort of the number of injuries, I think it cited 6, including McGee's, would this establish some sort of conscious indifference? And the court noted that none of the past injuries at the cliffs at Cameron Park appeared to have involved a large piece of earth falling from a cliff or even a rock fall in general, suggesting that perhaps people had fallen from the cliffs for other reasons. So this particular injury was qualitatively different from prior injuries. And moreover, it didn't make the situation any less obvious to the recreational users. The court noted that if liabilities imposed here, it would pose an unreasonable burden on the landowner. to even have public parks of this nature that are more natural, great outdoors. That would be unreasonable and unduly burdensome to ask a landowner to seek out every naturally occurring condition that might be dangerous and then warn of the condition or make it safe. You know, as if you should have signs all around, you know, the Grand Canyon that, hey, you know, be careful, it's a long way to the bottom. I mean, warning signs are not required for such open and obvious risks. You don't have to foresee the exact risk as long as the general scope of the risk would be apparent through the reasonable use of your senses, which is what the case was here. So the court held, and this fits with general principles, a landowner generally owes no duty where a claim is premised on injury caused by a naturally occurring condition. And if there's no duty to warn, not even ordinary negligence, the court went on to find certainly a landowner would not generally be considered grossly negligent to protect or warn against dangers of a natural condition under the state recreational use statute, which even makes it more conclusive and definitive that there's no landowner liability here when you throw in the recreational use statute. And where willful wanton exception, where there may be liability under state recreational use statute, requires total indifference, utter disregard on the part of the landowner. Here the state Supreme Court noted there was in fact evidence of reasonable care. That the court, while it would not be required under the recreational use statute, where the landowner has no legal duty to guard, warn, or make the premises reasonably safe, here the city had actually done something by posting this prominent sign in front of the cliff stating, "For your own safety, do not go beyond the wall." So in doing something, it would run counter to the legislative intent of the state recreational use statute by doing something to somehow lose your available immunity under the state recreational use statute. So even assuming if the city owed McGee a duty, and the court here found that it did not because it was an open and obvious natural hazard, the cliff, and assuming the city knew of an extreme degree of risk, to establish willful, wanton, gross negligence, given the existence of the sign, the fact that they did something, the court found that that would certainly not show the necessary conscious indifference to establish liability under the recreational use statute under the willful, wanton misconduct exception. That the wall and the sign, in fact, evidence some degree of care to provide a barrier to prevent patrons from going to the cliff edge, telling them to stay away from the edge. So as a result, keeping in mind that a warning may not even be required, generally it's not required where you've got an open and obvious natural hazard as the cliff is here, it rejected Kirwan's contention the sign was inadequate and it failed to identify the particular hazard applicable to this case, the risk of fatality resulting from the condition of the park premises. An adequate warning doesn't have to tell you, oh, here's the risk, and if you don't listen, you're going to die. And furthermore, it doesn't have to identify every specific risk, even where a warning would be required, which is not the case here. It simply has to be sufficient to put you on notice of the general scope of the risk. So we don't intend to discourage landowners from posting detailed warning signs where necessary. But here, they found that the barrier and the warning to stay away was sufficient to avoid any showing of what? Conscious indifference to the right, safety, and welfare of others, which you would need to show in order to overcome the immunity of the state recreational use statute. Kirwan went on to allege that somehow by allowing continued access to the cliffs by park patrons, there have been previous injuries and the areas had unstable rocks, that somehow that was evidence of conscious indifference on the city part. The Supreme Court rejected it because they said, well, given the barrier and the warning sign, they weren't actually allowing park patrons such as McGee into the area of the unstable rock. On the contrary, they were telling them to stay away and not to go on the cliff for his own safety, and he chose to disregard the sign. So as a result, the State Supreme Court here found that Kirwan had failed to demonstrate as necessary to overcome the state recreational use statute any evidence of conscious indifference. And under a state recreational use statute, where it applies, the general rule is there's no duty to guard, warn, or make the premises reasonably safe. Particularly, as noted in the court here, where you've got natural conditions. Even absent a recreational use statute, open and obvious natural conditions, the landowner owes generally no duty to warn of those types of situations, because the general scope of the risk when you're in the great outdoors should be open and obvious through the reasonable use of your senses. So as a result, State Supreme Court here reversed the judgment of the appeals court, which said that it should not have been dismissed, and reinstated the action of the trial court, which had effectively dismissed Kirwan's claim based on the state recreational use statute. Now let's compare that case to the Rhode Island case, where here you have a series of, as noted, multiple tragedies that are fairly close in time and character that may be sufficient to establish the necessary level of conscious indifference to overcome immunity under the state recreational use statute. And keep in mind, although most of these statutes are very similar, there are minor jurisdictional variations. And we're dealing with the Rhode Island State Supreme Court as opposed to Texas here. And here they noted we're faced with another case. There were earlier cases, a series of earlier cases that went to the court, all of which involved a catastrophic injury on the Cliff Walk, which is a major Newport tourist attraction. And the court described the Cliff Walk as 1,800 feet along Newport's shoreline, high above the rocky Atlantic coast, and majestic cliffs, scenic viewpoints that beckons hundreds of thousands of visitors every year. But unlike the previous set of circumstances, perhaps this situation, this tourist attraction, may indeed be much more treacherous than it appears to be. Now, while part of the Cliff Walk was over private land, the city had a public easement over this land, so therefore it controlled that area, and the city had assumed authority and maintained the Cliff Walk. So as the owner or occupier of land, this particular site, they were legally responsible for it. Now, the facts of the case August 20, 2000. Newly married 23-year-old Cynthia Berman, his wife Sarah. They were Newport, belated honeymoon. They were from Brooklyn, New York. They decided to take a late afternoon tour of the Breakers, one of the historic mansions in Newport that was owned and operated by the Preservation Society of Newport. Paid admission to tour the mansion. Now again, recreational use statute, public rec use free of charge, but the admission here was to tour the mansion, not later as they went on to the cliff walk. So they would be on the cliff walk free of charge. And during the tour, the Society's guide pointed out the cliff walk, which runs along the Breakers' property, separated by a fence, and suggested that they, quote, experienced the cliff walk. So after the tour, Berman spent some time enjoying the grounds around the Breakers' mansion, and then they decided to take an excursion on the cliff walk. So they then exited the fenced-in area, the Breakers, where they had paid to be on the site. Now they're on the cliff walk, hadn't paid, free of charge. And they went along the Society's property to Ochre Point, and they said there were no signs warning of the cliff walk's potential hazards at either the Breakers or the Shepherd Avenue entrance where they gained access to the cliff walk. And after they reached a paved portion of the cliff walk, they noticed a, quote, beaten path which they assumed would guide them to the water. So Cynthia took the lead, proceeded down the path with Sarah close behind. Suddenly, the ground beneath Cynthia's feet gave way, plummeted approximately 29 feet to the rocks below, and sustained catastrophic injuries, which rendered him quadriplegic. And it brought a suit against the city of Newport, alleging that the city of Newport had negligently caused Cynthia's injuries by failing to properly inspect, maintain, and repair the cliff walk. So where you generally, absent a recreational use statute, open land up for public park purposes, individuals on the site traditionally would be considered invitees. And for invitees, as a landowner, you owe a legal duty to guard, warn, or make the premises reasonably safe. So they're alleging that indeed the city of Newport had failed to do so. But if the state recreational use statute applies, you have no duty to guard, warn, or make the premises reasonably safe. As we saw in the previous case, you simply have to avoid willful wanton misconduct. So further, the plaintiffs allege the city knew of premise defects on the cliff walk and had failed to guard or warn against them. And this again will be invitee standard of care. If the recreational use statute applies, we have to see some sort of evidence of conscious indifference. Trial court granted the city's motion for summary judgment, effectively dismissed the case based upon the Rhode Island recreational use statute and the Berman's appeal. Now we'll see one of these minor jurisdictional variations in the Rhode Island recreational use statute refers to this concept of a discovered peril. And we'll take a look at the exception. Here's the general and owner of land permits without charge recreational purposes, does not extend any assurance the premises are reasonably safe, as you would with an invitee, does not confer the status of invitee or licensee to whom a duty of care is owed. We'll see, in fact, under the recreational use statute, a recreational user is afforded the same duty of care or legal protection that is afforded to a trespasser. And to a trespasser, you owe no affirmative duty of care as a landowner to do anything. You simply have to avoid what? Willful, wanton misconduct, intentionally hurting them, sometimes referred to as having a man trap on the premises. So the exception, nothing in this chapter limits in any way liability which otherwise exists for what? Willful or malicious failure to guard or warn against a dangerous condition. And adds this wrinkle, after discovering the user's peril. So here, we'll see under the facts, and as noted at the outset, the court says, here's another one of these catastrophic cases coming to us involving the cliff walk. So where they distinguished the cliff accident in Kirwan from other incidents, here there seems to be, as we'll see, the court finds more of a pattern and perhaps conscious indifference on the part of the city, unlike we saw in the Kirwan case. So, once again, what's the purpose? How do recreational use statutes work? You open your land for public rec use free of charge. You owe no duty, legal duty, guard, warn, or make the premises reasonably safe. Simply have to avoid, refrain from willful, wanton misconduct. If you are guilty of willful or wanton misconduct, then there may be liability despite landowner immunity under the recreational use statute. And that limited liability is the same status traditionally that's afforded to trespassers. So recreational users, where the recreational use statute applies, the legal duty owed to them is the same as you would trespasser. You have no affirmative duty to do anything. Here, where in some other jurisdictions it's open to court interpretation, and some statutes specifically exclude public landowners from the statute, others specifically include them, or the courts have interpreted it one way or the other. Here, any doubt was resolved in Rhode Island because in 1996, the statutory definition of owner under the Rhode Island recreational use statute was expanded on the statutory term definition of owners to include the state and its municipalities. So once again, liability of any would have to be based on a showing of willful or malicious conduct. And so the issue was, under the facts here, could the city of Newport be potentially liable? Was there evidence of willful or malicious conduct such that the trial court had erred in dismissing the case based on the recreational use statute and should have allowed it to proceed to trial? Here, in terms of this discovered peril, which is a wrinkle in the definition of willful wanton misconduct under the Rhode Island recreational use statute, here the Rhode Island State Supreme Court found the city had effectively discovered the user's peril based upon the dangers surrounding the cliff walk. Specifically, and they noted tragedies such as this have occurred on multiple occasions. So for this to happen multiple times and do nothing in response might establish the necessary conscious indifference. Where in the Kirwan case you had the barrier and the sign, don't go beyond here for your own safety. Here, multiple occasions and nothing in response on the city's part, perhaps that would indicate the necessary conscious indifference on their part, utter disregard for the physical well-being of others, necessary to make a case for willful wanton misconduct, including the Rhode Island requirement of this once a peril is discovered. So here, looking at whether they had discovered the user's peril, not only for the Bermans, but generally tourists using this site, said it was beyond dispute many years the city had actual notice of dangerous instability of ground beneath the cliff walk and its eroding edge. So they were aware of erosion under the cliff. That wouldn't be apparent to the recreational user, unlike the cracks and stones that were apparent in the Kirwan case. The erosion may not have been as open and obvious, may have been more latent and hidden. And he said the facts here have a haunting similarity to the case of Michael Caine. The Caine case was decided earlier, Caine versus Johnson, 2000 case in front of the same Rhode Island Supreme Court. That here, as the Berman situation, Caine stepped from a paved area in a well-worn spot that appeared to be perfectly natural, and he fell to his death. Same situation that injured Berman after the ground gave way beneath his feet. So 9 years later, the Rhode Island Supreme Court has the same type of case before it, almost to the day, with Simcha Berman. And what appeared to be a well-worn grassy path appeared stable, as had happened to Caine. Here, once again, the ground gave way. And unlike the Kirwan case, where there were perhaps the cracked rocks and stones and the like, gave you some indication to the reasonable use of your senses, the general scope of the risk, this situation was much more dangerous than it appeared to be. It wouldn't necessarily be apparent to the recreational user, and clearly it was known to the city based on his previous incidents. So you do have a real imbalance of relative risk knowledge. Here the city knows much more than the user would, where in the Kirwan case the relative risk knowledge between the decedent and the city was pretty equal. So here the city, long before even the Caine tragedy, knew that forces of nature, that erosion was taking a toll on the cliff walk. The prior to Caine, in the Berman situation, noted in 1983 and again in 87, other individuals had fallen to their death from the cliff walk. And we don't see any indication of a response on the part of the city. So here, based on such facts, the state Supreme Court found the city had actual or constructive, meaning they should have known of a perilous circumstances, and had reasonable time, years in fact, to eliminate the dangerous condition, and failed to do anything. And as a result, the Supreme Court, that the city, given this known dangerous condition, had put members of the public in a position of peril, and perhaps evidence of the necessary conscious indifference over the long period of time and a number of incidents to establish the necessary willful wanton misconduct exception to the recreational use statute. So here, the state Supreme Court found enough evidence for a jury to reasonably conclude that the city voluntarily, intentionally failed to guard against dangerous condition, knowing there exists a strong likelihood that, in fact, did happen, that visitors would sustain serious injury or death. And under these circumstances, given such indifference, would overcome the applicability of the state recreational use statute, and then under once the statute would not apply, either because there's evidence of willful wanton misconduct, or if inapplicable, then under ordinary negligence standards, principles, the city would have an affirmative duty to guard, warn, or make the premises reasonably safe, which they had not done so. And here the court, in finding that the immunity under the state recreational use statute should not apply, they focused on the number of serious injuries flowing from a known risk. And they concluded that in passing this statute and extending the immunity to public landowners, to encourage landowners to make their land open for public recreational use free of charge, they said, we can't believe that the legislature intended to relieve the city from any responsibility to tourists that it encourages to visit the cliff walk. So they took note that under the recreational use statute, the applicable standard of care treats the recreational user, gives them the status of a trespasser to whom no duty of care is owed, except, as we've noted, to refrain from willful or malicious conduct. And here they said to treat recreational users as trespassers would not only be absurd but unjust. But I think a case could be made, given the nature of the defect here, the erosion known to the city over a long period of time, the number of identical incidents of serious injury or death, whereas the cliff injuries in the Kirwan case, his injury was qualitatively different from other incidents. Here you have a series of the exact same thing over and over again, and the city did nothing in response. They've already noted it's a discovered peril. I think you could find that there was evidence of conscious indifference and perhaps willful, wanton, or malicious misconduct to trigger the exception under the recreational use statute. They say, we're not persuaded the legislature intended the recreational use service to serve as an invitation to ignore known hazards while profiting from this major tourist attraction where such dangers are present. Now, in some jurisdictions, here no fee was charged for recreational use of the property, so the fee exception would not apply. Other jurisdictions where the statute refers to not fee for use of the premises, but does the landowner receive consideration or some economic benefits, that is also an exception, but that's not the case here. So here the court found that given these series of cases, tragedies that came before it, whereas the Kane case, they did find applying the trespasser statute, that there was no liability there. But 9 years later, faced with almost the same set of facts, this particular case, the state Supreme Court found otherwise, as opposed to what was the situation in Kane in 2000. He said, here, were we to interpret the statute in the manner the city suggests, it would serve as a disincentive to make necessary safety repairs. So it seems like they're applying the invitee standard of care and rejecting the notion that the state recreational use statute should apply here. I don't necessarily feel that comfortable with their reasoning. That in fact, they say it would serve as a disincentive to make necessary safety repairs to taxpayer financed recreational facilities or to warn of known dangerous conditions. Generally, the idea is that were it not for the recreational use statutes, such areas would not be open to the public. That if there's liability, rather than giving strained budgets to fix these things up, that the Cliff Walk or other sites may indeed be closed down. So in any event, they came to the same conclusion. I think could have come to the conclusion and found that indeed perhaps there was a case where a jury, as they noted, could find willful wanton misconduct under these particular set of facts, distinguished from the facts we saw earlier in the Kirwan case. So here the Rhode Island Supreme Court held the defendant city of Newport could not invoke the protection of the recreational use statute. That here, applying just general sort of invitee principles, they had a duty to warn or guard against the cliff's latent, meaning hidden dangerous conditions. That it wasn't an open and obvious natural condition like we saw in the Kirwan case. So as a result, state Supreme Court here vacated the trial court's summary judgment, which was based on the recreational use statute, and sent it back to the trial court, and having found the recreational use statute did not apply, then the jury would simply consider the case for personal injury liability for mere negligence. Should the city be liable in tort to an invitee for the failure to repair or remove a known or discoverable hazard within a reasonable time? And if that's impossible or impractical, provide an adequate warning, unless warning is not required if the condition is open and obvious. But here the court's already characterized this particular condition, unlike the open and obvious condition in Kirwan, that this condition was latent or hidden, trap-like, that it existed over a long period of time where the city knew about it and didn't do anything in response, and therefore certainly making a case for landowner liability. So that concludes our discussion of this particular case. In so doing, hopefully comparing and contrasting these two decisions gives you some more insight into how recreational use statutes work, juxtaposed to general landowner liability principles, particularly involving open and obvious natural hazards like cliffs. So although the facts are similar, as we've seen here, you can distinguish on the facts. Each cliff here is different, and as a result, what seems to be similar facts, when you distinguish them, you come to different results. In testing and analyzing, as noted here, these accidents test applicability of the recreational use statutes in 2 different jurisdictions. So this is Professor Kozlowski. We'll see you next time for another case review.